Yes, Mrs. Robin.
So if I can turn then to the exceptional circumstances that the judge identified in the present case, going back to paragraph 392, judgment page 123 of the a number of submissions were made on this by my learned friend. In my submission, adopting the points put to my learned friend by my lords, it is clear that what the judge is doing here is first setting out the elements of the proprietary stopple-ish equity, and it's an ish because it's not being relied on to claim a property right against somebody. It's being relied on to influence the exercise of the statutory discretion under section 39. That's why it's a proprietary and stopple-ish equity.
Well, the label may not matter. I mean, your point is that here is an assurance relied on by Matthew, acting to his detriment, and it is that combination of assurance plus reliance that makes it unfair or unjust, whichever word you prefer, to order a sale of the partnership assets.
Precisely. And I think my learned friend accepted that the understanding and reliance elements were made out, but he said the judge went wrong in referring to a moral dimension. And I respectfully adopt the point put by my Lord Justice Nugee that that wasn't what the judge was doing. What the judge was doing was saying, in considering what Matthew did, it has to be borne in mind that he was in a partnership, which was to run the business and make profits, and that has to be borne in mind in evaluating his conduct. That's all the judge was saying. And he was saying that Matthew went far beyond what was required for him merely as a partner, and a partner, just by being virtue of a partner, doesn't have an obligation to do any particular amount of work. It certainly doesn't have an obligation to go around seeking other people to put money into the business, which otherwise might be used for other purposes. So that's all the judge was saying there. And as for a lack of reference to unconscionability, the judge says, uses the words unfair and unjust, which are synonyms for unconscionability. So all of the elements of a proprietary estoppel equity were recognised in paragraph 392. And then the judge goes on, having explained that the equity may operate to prevent the liquidation of the partnership's assets if the court concludes that in any circumstances an order for sale would be unfair and unjust.
Sorry, where are you now?
Very halfway down page 124 at the top.
Yes.
Other factors. I think it was suggested that how can these factors be relevant? These factors are relevant because the nature of the equity is to influence the court's discretion, and the court takes into account, or can take into account, other factors. And the factors that the judge considered it right to take into account are then identified in paragraph 392 and in more detail in paragraphs 396, 397 and 398. The tax, Mrs. Cobden, Mrs. Jill Cobden's position, and the farm workers.
Why should the positions of third parties come into this?
Well, it was recognised in Guest and Guest that the effect of satisfaction of inequity on third parties can be taken into account, and it's recognised in Bahia and Sidhu that it can be taken into account in deciding what order to make under section 39. They are, it is a relevant factor. And the position was that in order to raise money for the partnership, I think it was in 2015 or thereabouts, there was a sale of the dairy herd, the cows that were milking, to a company which was mostly owned by Mr. and Mrs. Cobden, the parents, 75% owned by them. Cobden Farms Limited, owned through a parent company called Cobden Investments Limited. And then the cows were leased back to the partnership. So that provided a substantial capital sum. And thereafter, the position remained that the cows belonged to Cobden Farms Limited and were leased to the partnership. that the calves that were born belonged to the partnership, but then were sold to the company when they reached the point where they became milking cows. The arrangement entered into, as I say, to enable a capital injection to be made. That left Mrs. Cobden as the 75% owner of the company in a position where if the farm was sold, it would put her potentially in a very difficult position. That's the point being made by the judge in paragraph 397. My learned friend said in relation to paragraphs 396 and 397 that they hadn't been pleaded in the amended particulars of claim. That isn't the point that he took in his appeal skeleton argument. And our response is that the position of Jill Cobden was covered in Matthew's witness statement and in our skeleton argument for the trial. Position as to tax was covered in advice from the partnership accountants, which was included in the trial bundle and which was referred to in our skeleton argument for the trial. No pleading point was taken at the trial. And my submission, it was a case called Hawksworth and Chief Constable of Staffordshire, which, if necessary, we can get copies of, which says that if you want to take a point on the pleadings, on a point not having been pleaded, and therefore it shouldn't be taken into account, you should take it at the trial so that an application for permission to amend can be made, and you shouldn't take it for the first time on appeal. It certainly shouldn't be taken for the first time on appeal in oral submissions. So that's what I wanted to say about paragraph 392. My learned friend made a point about Daniel overbidding and paying more than Matthew. He made a number of assertions which aren't supported by any evidence and any findings in the judgment. He did refer to an offer that was made by Daniel. That is referred to in the judgment in the core bundle at page 62, paragraph 67. And in order to understand the offer described in paragraph 67, we need to turn back to paragraph 59. So what happened was that in April 2022, Matthew made an offer to purchase Daniel's share in the partnership and other assets as well, an interest in Whitcomb Farmhouse and in the Old Dairy, and Daniel's shareholdings in Cobden Investments Limited. And then paragraph 67 is Daniel's counteroffer, which was to buy the Matthew's interest in the same assets. It wasn't just the partnership assets, it was the farmhouse and Daniel's house and Matthew's shareholding. And there was also a requirement that Matthew and his family would have to leave their home, which is not owned by either of the brothers, it's owned by Mrs. Jill Cobden. My learned friend said, well, that was a better deal than the one that Matthew ended up getting when he bought out Daniel, but you can't compare the two. What Matthew bought was Daniel's interests in the partnership assets only. This was an offer relating to other assets, quite a lot of other assets, and also requiring Matthew and Hayley and their children to leave their home. So it's a non-comparable offer. And there's certainly nothing to justify the assertion that the judge should have found that Daniel would definitely have paid more than Matthew. But even if that is the case, then I adopt the work put by my Lord Justice Nugee that if there was a bidding war, Daniel would only have to outbid Matthew by a little bit, and how could that produce financial fairness to Daniel? In correspondence, offers were made by Matthew, by Daniel's share. There were no offers made by Daniel apart from that one that's referred to in the judgment, even though there were a number of letters from Matthew's solicitors asking Daniel what he wanted. My learned friend said it would be hard to apply proprietary estoppel to a partnership because the partners are co-owners of the partnership assets, and my Lord Justice Lewison asked why. In our submission, there is no difficulty in applying proprietary estoppel principles between partners. In fact, in Winter and Winter, where my Lord Justice Newey gave the leading judgment, there was a partnership, as I understand the judgment, and the claim was to an increased, or to a share of in that partnership. And the claim was upheld on proprietary estoppel principles. My learned friend's other criticism of the judge's formulation of the exceptional circumstances is that they're too complicated. The complexity simply reflects the facts of the case. There's no reason in principle for saying circumstances can't be exceptional because they require more than a sentence or two to explain. So, unless I could assist further on ground one of the appeal, I'll move on to ground two. And the court is, of course, very familiar with the principles of proprietary estoppel and the need to remember that it doesn't put matters into watertight compartments. One needs to look at matters in the round, and that the overall test is whether in particular circumstances it would be unconscionable for a party to be permitted to deny that which knowingly or unknowingly he's allowed another or encouraged another to assume to his detriment. So can I begin with the shared understanding? We can start on page 123 of the core bundle, going back to page 392. Paragraph.
A shared understanding is not on its own enough, is it?
No, not by
There's got
itself.
to be something which some of the cases describe as crossing the line.
Yes.
Here
Shared
you've
communicated
got a
understanding.
conversation in 2005 and 2006, which seems to be the foundation of the judge's findings on the estoppel question. He says at paragraph 350 on page 116, the 2005-6 conversation provides the basis for Matthew's expectation. So that's his finding on assurance, or whatever you want to call it.
Yes.
So that's the first step in any estoppel claim.
That is, he refers to the conversation there. In terms of context, there's one other pointed by way of context that we wanted to refer to, which is in the supplementary bundle at page 58. Is a valuation by Simmons and Sampson of Whitcomb Farm in 2006. And one can see from page 60 that the client was Whitcomb Farm Partnership, the instructing source for two solicitors. And about halfway down the page, purpose of valuation, possible partnership dissolution. This was a valuation obtained for the purpose of Willie leaving the partnership and being brought out. And one point to note on page 74, paragraph 16.1, is that at that time it was said by the valuers that the farm buildings were in need of repair, improvement and general upgrading, making the long-term operation of the dairy from the holding somewhat unlikely. And then the context of the conversation was it was at about the time that Willie was leaving the partnership. And if we can then look at Matthew's account of the conversation in his second witness statement in the supplemental bundle at page 34. perhaps I could ask the court to read paragraphs 98 through to 104.
Sorry, which page?
Page 34 of the supplementary bundle. Paragraph 104, he says,
Sorry, I haven't got there yet.
so sorry, Mum. So that was Matthew's evidence about what he understood in paragraph 104 from the conversation. And then Haley's evidence, which the judge also accepted about it, is on page 54. Paragraphs 50 to 52.
Yeah.
So her evidence in paragraph 50 was at the end, I know that it became Matthew's aim to be able to buy Daniel out, knowing that he continued to be under pressure from Georgina to move. My learned friend says, well, it must have been obvious that they weren't going to move, but that wasn't Haley's evidence. We can go then to the core bundle, please, and page 103.
Sorry, just before you do,
Sorry.
you say it wasn't Haley's evidence. What time period are you referring to there?
She doesn't give a time period, but she says, I know that it became Matthew's aim to be able to dive Daniel out, knowing that he continued to be under pressure from Georgina to move. Certainly there was other evidence from her which isn't in the supplementary bundle to the same effect.
Right, so where are we going? Judgment?
Going to the judgment, please. Core bundle, page 103, paragraph 262.
Yeah.
Here, the judge is dealing with Daniel's evidence. Daniel's amended defence denied this took place, and in his principal witness statement, he said he would have remembered such a significant conversation, which was no doubt right. The judge didn't accept his evidence. We turn back to page 101 and paragraph 255.
Yeah.
Judge said Daniel was not an impressive witness. I felt there was a lack of candour in his answers and unwillingness to help me to get a full understanding of matters relevant to the determination of the dispute. In other words, he was deliberately withholding information he knew he would harm his case. If we can go back, so Daniel said, I would have remembered it if it happened, but it didn't happen.
Well, the judge found it did happen. We've got a finding to that effect.
Indeed. we go back to the supplementary bundle, please, just look at a couple more paragraphs. In Matthew's second witness statement. The first one's at page 41. Paragraph 155. And then paragraph 157, just down to the top 4 lines of the next page. And then page 43, paragraphs 164 and 165.
What are we to make of this? If you can show us findings where the judge accepts all this, that's one thing. But it's not easy to find the judge making findings on the basis of this evidence, except for a very general statement that Matthew seemed to be a reliable witness. I mean, is that what you're relying on?
I rely on the fact that the judge said that he accepted Matthew's evidence and found him a reliable witness, and only on one point he felt he hadn't got his evidence quite right.
Yeah, about the part that Daniel played in the farming business.
Yeah.
But paragraph 164 you've just shown us is a very clear statement that Matthew would not have taken the decision in 2013 to build the new dairy enterprise had it not been for the conversation. Now, I think one will look in vain for a finding to that effect by a judge.
But the judge's finding is encapsulated in paragraph 392 of the judgment, which is...
Well, is that his finding? That's his formulation of what he thought amounted to exceptional circumstances. But when one looks at what he actually finds on the facts, it really starts, I think, at 348, paragraph 348, 116. He says there was a conversation. And then at 350, the conversation provides the basis for Matthew's expectation. Then there's some further encouragement in 2021. Matthew acted on the conversation by working with Mr. Bray on the figures for a buyout proposal. Well, that's not until 2022. And then he deals with the undermining of the expectation. But where does he find reliance and some sort of change of course by Matthew? I mean, he does say in very general terms at 394 that Matthew's established the equity, and he says earlier on that he thinks that Matthew is a reliable witness. But in terms of actual findings, we're pretty thin on the ground.
I would accept that the judge has not been through every piece of evidence and identified which supports his finding. And it is in my submission, the way he's formulated it is slightly unusual in paragraph 392. But he does say these are the exceptional circumstances that justify the conclusion that this is a fifth example of the case where it's appropriate to make a science order. So 392 is at the heart of his judgment, and that includes the understanding, the devotion accordingly to the firm's business, the understanding is sufficiently clear from the dealings between the partners and the subsequent reliance upon it throughout the life of their partnership.
Now you get that, do you, from the opening words of paragraph 392? If it is necessary to summarise the basis of my decision on the facts.
Yes.
So although 392, when you first read it, looks as if it's formulated as a fifth exception to bar here, you say it's really a finding of fact on the facts of this case.
My lord, I do say that, yes. It is,
And you get that from the opening phrase.
yes. It is, in my submission, clear that he intended paragraph 392 to encapsulate the reasons he was making the order he was making. It is true that he hasn't spelt out in the previous part of his judgment all of the facts that were in evidence from a witness whose evidence he accepted that justified that finding. It has often been said that a judge is not required to set out every piece of evidence that feeds into the
No, but basic building blocks are desirable.
I mean, the formulation of 392 is also, on the face of it, expressed in a more abstract way, so that it isn't tied to the facts of this case, albeit that it may be inspired by them. I mean, the equal partners in a partnership at will. It's not this partnership.
My lord, I accept that the language that the judge has used is unusual. It is. It's one would normally expect to see these findings set out in separate paragraphs and then a conclusory paragraph saying in the light of the facts, but this is the way that this judge has chosen to express himself, and he clearly did have all these facts in mind in making the order he did. In paragraph 394, he says Matthew has established such an equity.
That's it. That's the finding of fact. That everything I've said in 392 as a principled potential fifth exception, then that word such, it's really the word such, in 394 allows you to say, and I find on the facts of this case all these things have been established.
Well, in my submission, one gets that from 392 by itself, but 394 can be taken as further confirmation that that's what the judge is intending to do. Otherwise, paragraph 392 is inexplicable. It's no more than a discursion into some imaginary case which may or may not exist. But that wasn't, in my submission, plainly isn't what the judge was doing in 392. What he was doing was saying, here are the key points that I am relying on in making the order I'm making.
But you've really got to rely quite heavily, haven't you, on paragraph 216, where the judge says right at the end, it's enough for me to say in the light of testimony given by Matthew on the key points, I'm reassured that what he said in his witness statement was a truthful account of other matters, more likely to be an accurate account. That's your peg, is it, for getting in what Matthew said in his witness statement?
Yes.
Because what he said, for instance, about I wouldn't have gone for the 2013 expansion, but for the conversation, is not a finding of fact the judge explicitly makes.
No, it's a. If one treats paragraph 392 as I submit as being the core of the judge's reasoning for making the order he's making and as encapsulating the findings of fact he's making, then it is true he doesn't spell out every aspect of the evidence which entitled him to make the finding. For example, an understanding that one partner would himself carry on the business when the partnership eventually comes to an end.
So can I just take that a stage further? Still on page 123, he's talking about detriment, I think. And then he comes on 6 lines on 124 to say the court is entitled to consider, and so on. So adopting your approach, it would be the court is entitled to consider Matthew's individual efforts in developing the partnership business, and to do so with a particular focus upon a comparison with the business as it was at the partnership's inception, and so on. So suppose that had been stated as a separate sentence applied to this case. The court is entitled to consider Matthew's individual efforts. would that do as a finding of detrimental reliance?
Depends what the efforts were. The efforts were in evidence, and we have summarised them in our skeleton. I'm going to come on to them if I may. But yes, as a summary of the evidence, it is quite sufficient.
Yes.
I have addressed the court on the reference to what my learned friend said it was a moral assessment, like the judge which I submitted wasn't. It was an aspect of the judge's assessment of unconscionability. Now turns back to page 342, so it's paragraph 342 on page 115. This is where the judge said, paragraph 341, as between these two brothers, it's Matthew deserves to be the successor to the farm. So my submission isn't making some moral judgment, it's making the assessment that it is fair and just that he is the successor to the farm, providing he pays a fair price. And then he says the basis for that observation appears in my assessment of the impact of all the factual evidence addressed in section E above. The evidence of Matthew and Mike Gray was compelling in this respect. So there he was referring to all the evidence that Matthew and Mike Gray had given about building up the business. I do accept the judgment would be clearer if paragraph 392 had been set out as separate findings of fact and there had been a more detailed examination of the evidence. But the question for this court is, first, did he make these findings of fact, which I submit he did? My then friend's appeal is premised on the basis that he did, but he shouldn't have.
Why does he bother to say at 340 to 341 that it's Matthew who deserves to be the successor, which looks like who do I think has a better claim? What Mr. Pierce characterised as a moral assessment. What relevance is that to the questions he has to decide?
It is, again, it would be better to put it after he puts it before the reference to the conversation, but it is a finding he makes having regard to the evidence that Matthew has a claim, it's headed the rival claims to the farm. He does say the stronger moral claim, in paragraph 340, and then in 341 he says it deserves to be. The reasons for that are explained when we get to paragraph 392. The reason he deserves to be the successor is reasons that are summarised in paragraph 392. And it has been said many times that judgments
Can be better written.
can be better written. In this judgment, and in fairness to the judge, he was trying to do the best he could to get the judgment out as quickly as he could.
And he covers an enormous amount of material.
There was an enormous amount of material, and he had to deal with the in situ being decided and written submissions on that. He devoted a great deal of time to that, and I would accept that the judgment would be clearer if the building blocks were set out separately rather than being encapsulated in paragraph 392.
I mean, to take one example, which is perhaps troubling, he says at paragraph 225, page 96, that Mr. Pierce-Smith asked Matthew questions which related to his suggested detrimental reliance on the 2005-2006 conversation. And then with the one exception of the Longford Meats dispute, that just vanishes.
Well, yes, I'm not sure I can say more than that.
He accepted Matthew's evidence and it's in Matthew's witness statement.
And he accepted Matthew's evidence. It's in Matthew's witness statement, and in paragraph 392 in my submission, he made findings based on all the evidence.
And I suppose you're entitled to say this isn't a reasons challenge.
Well, no, the challenge to this judgment is not on the basis that paragraph 392 isn't spelled out more clearly. It's on the basis that the judge shouldn't have made the findings he did make. If it had been a reasons challenge, then, as I understand it, that should be raised with the judge at the permission to appeal stage, and the judge should therefore be given the opportunity of expanding his reasons. But the application of permission to appeal was put on the same basis as the appellant's notice, namely that the judge shouldn't have done what we submit he did, made the findings that we submit he did make.
Yes.
The judge did refer, I think, to the conversations that took place on a number of occasions. I'll just find the reference to that. It's page 92, paragraph 204 of the judgment. In the light of what Matthew and Daniel have both said about a number of conversations during the life of the partnership about Matthew buying out Daniel, albeit rather heated ones to a greater or lesser degree according to their respective testimony. So he does refer to that as part of the material he's taking into account.
222, is that the same thing?
Yes.
Okay, it's slightly odd because he's here reciting Matthew's evidence rather than clearly making findings of fact.
Yeah, except he does preface 213 and 216 by saying he accepts Matthew's evidence. But after the dairy unit had been built before the present dispute, again, you need to connect those conversations with some sort of detrimental reliance.
Yes, which was done in Matthew's evidence, but apart from paragraph 392, not clearly done in the judgment. If we could go back to Matthew's witness statement, subject to all the points that have been made, I would still wish to show the court parts of it, if I may. Just two more paragraphs on the mutual understanding point. Paragraph 164.
Yes.
Sorry, where are we? Oh,
Page 43 of the supplementary bundle, paragraph 164. And also paragraph 165.
165 is what the judge is referring to in the passages my Lord Justice Nugee drew attention to, but he doesn't in terms incorporate 164.
No.
Yeah.
The judge did refer in his judgment to the October 2021 conversation. That was on the core bundle, page 96, paragraph 224.
Yes, that's when he says that Matthew acted on the conversation.
Yeah.
That's 351. Acted on that conversation.
And on page 102, paragraph 260, subparagraph 4, the judge records Daniel's claim in his witness statement that in early April 2022 he had no idea that Matthew wished to buy him out of the partnership, and that claim didn't survive. And then at paragraph 270 on page 104, the judge said that Daniel's account of that conversation was highly unsatisfactory, and his development of it obviously encourages the thought that there was a conversation in October 2021 which was of greater significance than he's prepared to admit. It was a reasonable inference that Daniel's evidence about this was so unsatisfactory because he knew that he had agreed in October 2021 that Matthew should buy him out, and that this reflected what had been their common understanding since the start of the partnership. This is an example of a lack of candour referred to by the judge in a passage I took to earlier. So in our submission, there was sufficient evidence to justify what we say are the findings in paragraph 392 on the common understanding. And my learned friend says, well, the particular conversation concerned the probability that Daniel at some point would agree to move to Taunton. And therefore the assurance was nothing more than, well, if I move to Taunton, then you can buy me out. That isn't how the judge understood it. That isn't how Matthew understood it. Daniel wasn't candid, so the judge didn't get the benefit of honest evidence from him as to how he understood the position. And we submit it was a perfectly rational evaluation of the evidence by the judge, that bearing in mind what happened with Willie, that he left on the basis of being paid a sum based on a independent valuation, that the understanding that arose from that conversation and the other material I've shown the court was that in due course Daniel left the business, if he left the business. Matthew's position was not that he wanted Daniel to leave the business. He didn't want Daniel to leave the business. He knew he might not be able to afford to buy him out. He knew he couldn't afford to buy him out for a long time. And he says in his witness statement, I wanted to build the business so there'd be enough value there so I could buy him out in due course. He explained that on a number of occasions. For example, in the supplementary bundle, page 182, top left-hand box, internal page 64, line 14. Surely if you expected or understood Daniel was going to retire from the partnership, then the question of what share Charlie would receive would not be relevant with it. Answer, I was not looking for Daniel to retire from the partnership. It was only if Daniel chose to retire from the partnership. And then
Did the judge find that this conversation about the children's shares took place?
Matthew accepted it took place. It wasn't disputed by Matthew.
Disputed, yes.
But his answer to it was, I wasn't looking for Daniel to retire. If he didn't retire, he didn't retire. He would just carry on. And in due course, Charlie would inherit his share. But the point was that if he left, and this was the crucial point, it never occurred to Matthew that he'd be faced with the situation where the whole thing would be sold. He would be deprived of the opportunity to go on with the business that he's worked so hard and put so much time and money building up. As for detrimental reliance, what the judge said in paragraph 123, as the court has seen, is that partner has devoted himself accordingly to the firm's business and its development in anticipation of that event.
Sorry, paragraph 123.
This is back to paragraph 392.
Oh, 392, I beg your pardon.
Yes, I should say also that Daniel accepted that there was never any suggestion until the dispute arose in 22 of the sale. And we have a reference to that in our skeleton.
Yeah. So
yes, sorry. I'm going back to paragraph 392 of the judgment core bundle, page 123. And paragraph 392, as far as reliance is concerned, he says the understanding is sufficiently clear, and then he says, and the subsequent reliance upon it throughout the life of the partnership sufficiently identifiable and substantial to support the conclusion it would be unfair and inequitable for the other at the partnership's end then to insist that both partners' shares in the partnership assets should be liquidated through their sale. And that reflected Matthew's evidence on reliance, and I think the court has seen some of that already. If we go back to the supplementary bundle, page 35, starting at paragraph 107, if I can ask the court please to read paragraphs 107 through to 111. And if I can ask the court please to go to the core bundle, page 215. Perhaps starting at the bottom of page 214, and in paragraphs 42 through to 48, we summarise various sums of money that Matthew was responsible for having introduced into the partnership.
Yes.
With references, I won't go through all of those because the details don't matter, but I should just correct one reference at paragraph 46. The reference should be to, instead of being to paragraph 244 of the judgment, it should be to page 195 of the supplementary bundle.
Yes, I was looking for it in the judgment, couldn't find it.
I'm sorry about that. That was a mistake. And paragraph 45, I just should explain the £873,000. That was the money that was paid for the cows that were then sold to Cobden Farms Limited.
Yeah.
My learned friend says, well, everything that Matthew did was done as a partner, which is true, but a partner doesn't have to work very hard. A partner doesn't have to arrange for their father and put in money and put in their own money. And there are proprietary estoppel cases where the claimant has succeeded, even though everything they did was done as a partner. Spencer and Spencer is one which is in the authorities bundle. It's necessary to turn it up, but it was a case where Michael Spencer was made a partner at the age of 19. He ended up owning 95% of the partnership. He ended up with a capital account represented by liquid assets of £1.4 million and a pension of £745,000. But the judge said, well, he's positioned his working life on the basis of assurances that he'd get the farm as well as the partnership business. But Winter and Winter was another case of the same type. And the judge did take into account in paragraph 392 of the judgment the fact that Matthew was a partner and at least some of what he did could be explained by reference to him being a partner. But one point in the judgment I did want to go to is in the core bundle, page 90. Paragraph 205, judgment. So the judge says in paragraph 392, I summarise the basis of an equity broadly similar to proprietary estoppel which supports making of a side. So that perhaps can be read with paragraph 392 to fortify the submission I've already made.
Meaning, meaning that it is amounts to finding a fact, or what?
Yes, meaning that paragraph 392 is to be treated as his finding of the facts which support the making of the size order which he then goes on to make.
Yeah, it seems a bit funny if paragraph 205 he was saying, well, I've decided the case, rather than talking about the legal implication of where he's going to.
Yes. In terms of the assessment that it would be unfair and unjust to make an order for sale, which the judge say in paragraph 392. One point again coming from Matthew's evidence and not specifically referred to in the judgment, but I would submit endorsed by his general acceptance of Matthew's evidence is in the supplementary bundle at page 50. And paragraph 527 of Matthew's second witness statement.
Sorry, Mr. Jordan, would you give me the reference again?
Page 50 of the supplementary bundle.
50.
Page 527, paragraph 527.
Yeah. Yes.
So this is a quite different sort of case to Bahir and Sidhu, where Mr. Bahir, Lady Justice Andrews said, and indeed the judge said, Mr. Thompson said, could very easily replace the unremarkable investment properties. And that is what the judge did say, going back to the judgment in the call bundle on page 69. Paragraph 105. So the case has never been just about money, indeed allowing for the fact he's prepared to pay Daniel what he believes to be a fair price for Daniel's financial interest. Matthew, it is not really about money, i.e. financial gain within the dissolution accounting process at all. And he says the same on page 79, paragraph 156. Sentence, Matthew's case is not about money, and his expectation of becoming the successor to the farm is not an expectation of obtaining a financial advantage at Daniel's expense. And Daniel's position was different to that. And that's apparent from something he said in his oral evidence in the supplementary bundle, page 197. In the top left-hand corner, internal page 411, starting at line 9. Question: it is his creation, it is his baby, he cannot bear the thought of it being sold. You are perfectly happy for it to be sold if it is the way of getting the most amount of money. Is that not the reality? Yes, it does come down to that, yes. Daniel's position was he was interested in the money he could get. Matthew's concern was to retain the business. He'd worked so long and put so much effort and time and money into building it, which he couldn't replace.
But that couldn't of itself be sufficient to justify a size order, could it?
Not by itself, no.
No.
But as part of the overall picture summarised in paragraph 392, we could. In relation to the supporting factors, I've addressed the only point my learned friend made about those in his oral submissions was that they weren't pleaded, and I've addressed that. I'll just briefly say a word about each of them, if I may. The position as far as the tax was concerned is there was advice from the partnership accountants, who of course acted for both parties, they weren't partisan. Their advice is in the supplementary bundle at page 567 it was in the trial bundle that was referred to in our skeleton argument. And essentially they explained that it made no difference to capital gains tax whether there was a sale between the partners or to a third party, but it did make a difference if there was a sale to a third party in the case of income tax, because there would be tax to pay on the difference between the cost of the stock and the sale price. And in the case of plant and machinery, which had been written down with capital allowances, there would be an income tax charge on the difference between the sale price and the written down value, which they said together would come to £843,500. So that was a relevant factor from Daniel's point of view as to whether he was likely to be prejudiced by a sire's order. Because if the farm was sold to a third party who was willing to pay more than the valuation put on the land and buildings by Mr. Townsend, it would have to be quite a lot more to make up for the tax disadvantage. Bearing in mind that the judge added 5% to Mr. Townsend's valuation, which was what Mr. Townsend said the margin of error was. If you take into account the tax that would be payable on sale to a third party, you have a even more substantial margin. And then of course there's the costs of sale as well, the cost of a receiver who would have to be appointed, plus the cost of the selling agents. So that was a legitimate factor for the judge to take into account, and considering whether it was just to Daniel to make the order that he did make. I've already addressed Jill Cobden's position. As for the farm workers, the concern was, Matthew said this in his witness statement, and the judge reflected it in paragraph 398 of the judgment. The concern was if the farm was put up for sale, farm workers would be concerned that they would lose their job and they'd start looking for other jobs.
Wouldn't they go to the purchaser under 2p?
I'm sorry.
Wouldn't they go to the purchaser under 2p? The protection of employment transfer undertakings.
Yes, but psychologically, knowing that that might or might not happen, certainly Matthew's concern was that once it's known that the farm was up for sale and that they could be made redundant, they'd probably start looking for other work. They might hang around and be transferred under duty and take their redundancy payment, but they might not.
No, that's putting it in terms of the interests of the partners, not the interests of the farm workers. Is that the right way to approach it?
Matthew's concern, which the judge, it's in, to see what the judge said about it. It's paragraph 398 of the judgment.
Well, he's effectively saying they might up sticks and go
Yes.
before the sale.
Once it's known the farm is for sale, and Mr. Townsend said, as the judge says in paragraph 398, sale of farm typically takes 6 to 9 months, might lead to staff retention issues, and might mean the end of the business before the sale was completed, so that even if ultimately Matthew was the highest bidder, there might be nothing left.
So in this respect, it's nothing to do with the interests of third parties, it's to do with the interests of the partnership.
Yes. Jill Cobden is a third party interest, the farm workers is the risk that even if Matthew was a successful bidder, the business might not survive.
And just before you leave Jill Cobden, you said that guest and guest recognised that the interests of third parties could be relevant. I'm afraid I don't remember that. Can you
let me find
find
the,
that?
Let me find the reference to that. Sorry, just give me one moment.
Yeah.
It's paragraph 80 on page 256.
Thanks very much.
256 of the bundle, that is supposed to be.
Yeah.
Thank you very much. Ask itself whether it would do justice between the parties and whether it would cause injustice to third parties.
Yes.
May I just turn my back for one moment? I turn then to the question of evaluation evidence. And my learned friend's first ground of appeal here, ground 3.1, is that the judge was wrong to make a size order on the basis of expert valuation as a matter of principle. But that's what a size order is, so it can't be wrong in principle to make an order based on evaluation. And then it said that it was wrong to make an order here, given the evidence, because of the profits being made by the business. And the question for the judge was one of evaluation, whether the expert evidence was sufficiently reliable to justify making a size order. And paragraph 408 of the judgment, page 127 of the bundle, said, I'm satisfied that the valuation evidence in this case does provide a reliable indication of market value of the partnership's assets. Making a size order in reliance upon it does not involve an unwarranted gamble with Daniel's prospects under the usual form of winding up. Mr. Townsend gave evidence at the trial. I think my learned friend suggested that he'd expected that questions of valuation wouldn't be dealt with at the trial, but that was addressed at the pre-trial review, and that's why Mr. Townsend was asked to come and give evidence at the trial and to update his previous valuation. So that whatever the position might have been before the pre-trial review, after the pre-trial review, there was no doubt that issues of valuation were going to be addressed at the judgment. And I can ask the court to look in the supplementary bundle at page 164. Bottom left-hand corner, in the internal page 284, the question was put to him, starting at line 21. The lack of directly comparable evidence is something which makes it more difficult for you as the value to be confident about what the farm would fetch if it were sold on the open market. Answer: I would put it a slightly different way. It's a more challenging valuation because the absence of directly comparable evidence, but it does not make me any less confident in the resultant figure because of the way I've approached it. So Mr. Townsend's evidence was he had confidence in his figure, and the judge was entitled to accept that evidence. My learned friend says that the dairy business was profitable, but that wasn't consistent with the case. There were losses, there had been losses in the past when the milk price dropped, and the latest set of accounts in evidence of a trial are at page 300 of the supplementary bundle. they were made up to the 30th of April. They were an earlier set made up to a date in February, but we don't have those. These are the latest set that were in the trial bundle. And look at page 306. You see that in the period from the 1st of October 2023 to the 30th of April 2024, the business has made a loss of £205,000. In addition, certainly Matthew's evidence was that the business needed to spend money on new machinery. There was quite a lot of correspondence about that. And the purchaser would also need to account for the cost of capital, either in the form of interest on a loan or the opportunity cost of investing capital elsewhere. And there are also substantial risks involved in the business. The profits aren't free money, and they're not reliable. There was evidence which the judge refers to in the core bundle at page 119. That's paragraph 367 of the judgment. At the end of that paragraph, it says, as Matthew's counsel observed, profits are earned by taking risks. By way of illustration, they referred to Matthew's evidence about the potential implications of some of the herd testing positive for TB in 2023. And that's explained on page 63, paragraph 70.
Sorry, I got lost. Where are you?
Page 63, paragraph 70.
Yeah.
Summarising the problems with tuberculosis in the herd. And in the last two sentences in paragraph 70, the judge says, Matthew also explained it might mean DEFRA insist upon a gamma test, which he says produces a lot of false positives. It could mean the loss of 30% of the herd for derisory compensation. Such a loss could set the business back 10 years. So that was a threat hanging over the business. The point that the judge makes and that we make is that Daniel didn't ask for a valuation of the business, although he could have done so if he contended the business had a value in excess of the assets.
That's the point the judge makes at 369.
Yeah.
119.
Yes. And what did happen is that the parties agreed, and the court directed in the light of that agreement, that Townsend should be appointed single joint expert. He had previously done a evaluation, which is in the supplementary bundle, page 80. Page 80 of the supplementary bundle.
Yeah.
And that was done in January 2022. And at page 92, in the third paragraph, he said, explains how he'd approached the valuation of the new dairy unit. And he says in the second sentence there, our valuation does not include any value for the going concern element of the element of value, which would take into account the enhanced level of profitability which we understand the unit is able to generate. So Daniel knew, and those advising him knew, that the way Mr. Townsend approached matters was to look at the value of the land and buildings as assets, but not to try and value the business. And it was against that backdrop that Mr. Townsend was then instructed to act as single joint expert. And the instructions are at page 129.
So what was the purpose of this, the valuation we've just been looking at?
That was for the bank to,
Oh, right. Okay.
they periodically they asked for a revaluation
Right.
to check that their security was still adequate. And Matthew asked for that to be brought forward to take place earlier than
Yeah.
it would normally take place, so that he could use the valuation as the basis of making an offer to buy Daniel's interest. So the letter of instruction is on page 129, and it starts by saying this is a joint letter of instruction. And over the page at the top, paragraph 3, this letter has been seen and approved by Mr. Ray, Daniel's solicitor, so it's accordingly a joint letter of instruction. And then the order is quoted at paragraph 5.
Mhm.
Parties have permission to rely on the written evidence of a single joint expert in Federation, Michael Townsend of Savills. And over the page, on page 131, at paragraphs 11 and 12, the author, Mr. Williams, says would ordinarily set out the property details. It's not necessary to do so because you're familiar with the properties which fall to be valued, because they've already been the subject of valuation by you, albeit instructions from HSBC. And then in paragraph 12, in preparing this letter of instruction, I've had regard to the report and valuation of January 2022. So the parties proceeded on the basis that Mr. Townsend was going to value the land and buildings, but not value the
Yeah.
business. And there was no suggestion that he should do otherwise. And in his oral evidence, he said he would have asked for evidence of profits if they were relevant, but he said that they weren't relevant. And one other point to make about his evidence in the supplementary bundle, page 157. These were questions put to Mr. Townsend by Mr. Ray, Daniel's solicitor. And question 2 was, what is the value of the farm buildings to the claimant or the defendant as opposed to a potential purchaser on the open market? And the answer to that is given on page 160. Question 2. He says, I don't believe this formed part of my instructions, which were, as I understood them, to provide expert valuation advice as to the market value of the real estate assets. Market value is defined within Appendix 4, and the claimant and the defendant would form part of the overall pool of potential buyers in any assessment of market value. So he said in terms that he had taken them into account in arriving at his assessment of value as potential purchasers. There was some cross-examination of him about marriage value, and he said that wasn't applicable, and the judge refers to that in the judgment at paragraph 334, as my Lord Justice Lewison pointed out. But there really is nothing in the criticisms that are made of the valuation of the submission. The judge was entitled to make the assessment he did that the valuation was sufficiently reliable to make it just to make an order for sale based on that, adding 5% to reflect Mr. Townsend's margin. One point I haven't addressed is the points that my learned friend made on the pleading. So can I ask the court to go back to the four bundle? The name particulars of claim, which start on page 156. There are a few additional paragraphs I wanted to show the court. The first is on page 158. So paragraph 8 pleads the 2005-2006 conversation. Paragraph 10 that was the basis on which Matthew and Daniel dealt with each other at all times thereafter. Paragraph 12 says, after the conversation, he worked tirelessly to create a successful business. Going on then, please, to paragraph 31. On page 162. Paragraphs 31 and 32 lead the conversations about selling his interest, which Matthew referred to in his witness statement, and the judge referred to in the judgment. Paragraphs 45 on page 164. Alleged in paragraph 45 that at all material times Daniel accepted that the partnership's expanded business would represent a commitment on the part of Matthew for the entirety of his remaining working life and provided an opportunity for his children to follow. Paragraph 49 says that Matthew made the investment of his available means of the partnership because of his understanding created by the 2005-2006 conversation and encouraged by the subsequent conversations pleaded in paragraph 31 above, that he would be able to continue to farm through the partnership. And then page 171, paragraph 81, which is referring to an offer by Daniel to buy out Matthew. Matthew rejected that offer, insisting that Daniel should comply with what had always been common ground between them. Daniel considered he wanted to cease being in partnership with Matthew, who'd allow Matthew to buy out Daniel's interest. So, with respect, it isn't right to say that the case was entirely founded on one conversation in 2005 and 2006. The pleading was.
Yes, but the judge seems to have found that it was. It says at paragraph 350, wasn't it, that this conversation was the basis for the expectation.
He does say that, my lord. Address the court on what I say is to be taken from other parts of judgment, particularly mainly paragraph 392.
Yeah.
Don't think our case would be advanced by my saying it again. Sorry, may I have one moment? Round one of our respondent's notice is a submission that if the principles stated over here in situ are as narrow as my learned friend says they are and don't allow for considerations of the kind set out in paragraph 392 of a judgment to be taken into account, then they are too narrow and this court should respectfully depart from them. We set out our arguments on that in writing.
Yeah. Do you want to add much to that?
Well, I could address them at great length, but I suspect that given the way that the appeal has gone so far, that wouldn't be a good use of time.
Probably not.
In that case, I will give way to my further duty Miss Fairley to address ground 2 of the appeal.
Yes.
Ground 2 of the respondent's notice.
Yes, I'm
Yes,
grateful,
Miss Fairley.
my lords. It's my client's has made an application seeking permission to rely upon his 8th witness statement dated 11th of March. I don't know whether the court has had an opportunity to read that statement. It is in the...
Yes, we have.
You have. If I can address you briefly on why we say that evidence should be admitted in this case. That there are 4 reasons. The first is because the evidence satisfies the 3 criteria set out by Lord Denning in Ladd and Marshall. We've gone through in the evidence in support, which is the second witness statement of Mr. Peter Williams. We've gone through those 3 criteria with reference to the evidence. I don't want to labour those points unless there are particular things that the court wants to be taken to on that. The second point that we make is that evidence to update an appellate court who is called upon to exercise its own discretion is a recognised exception to the general rule that a court won't admit evidence that was not available to the trial judge. We rely in support of that on the case of Kwok and Jan, which is in the authorities bundle.
Yes.
A2.
That was the point that Lady Justice Whipple made in the reasons for adjourning your application to the full hearing. That she said it only becomes relevant if we are satisfied that Judge Russell erred in law such that we exercise our own discretion.
Indeed, yeah, we accept that the evidence is only, we seek to adduce it in support of the second ground set out in our respondent's notice, which is that if this court comes to the conclusion that the judge's decision was vitiated by error, then in that case it would still be wrong to set aside the judge's order or to order a sale of the assets on the open market, which is what the appellant is asking this appeal court to do in this appeal. And we say that that's so having regard to the evidence. So, of course, if the court may take the view it doesn't wish to hear from us on that point, but we have come ready to argue the point as to why it should be admitted, and then if the court is minded to admit it, I'll address the court on why, having regard to that evidence, we say you shouldn't set aside.
Well, just let's get the legal framework clear.
Yes.
If we are satisfied that the judge did not make a mistake in his judgment, then this evidence is irrelevant.
Yes.
If we are satisfied the judge did make a mistake, whether it's fact-finding or legal principle, so that we could set aside his order, you rely on this evidence to persuade us not to.
Yes.
And if we nonetheless do set aside his order and decide to exercise our own discretion, you rely on this evidence to influence our discretion. Is that right? So there are two.
Exactly
there are two purposes.
Yes.
Yeah.
Yes, and I think that's the point that was made in the order of Lady Justice Whipple. She refers to the fact that there was correspondence between the parties that was put before the court in effect, and I think one of the points that was made by the appellant was that the evidence only becomes relevant if the appeal succeeds. And we replied to that in correspondence saying, no, that's not the case. We accept the evidence is only relevant if the court concludes that the judge's decision was vitiated by error. But there's a gap between that and saying the order ought to be set aside, or a different order ought to be made in its place. So we would invite the court to consider the evidence at today's hearing. We say that where everybody is ready to do that, Lady Justice Whipple's order envisages that the application to hear the evidence will be heard at this hearing.
Speaking for myself, since we have not yet decided whether or not the judge did make a mistake, this evidence may never become relevant.
Yes.
So although we may look at it, the bene esse, whatever that means, because we never actually explain what it does mean, we will deal with it in our judgments, if necessary, when they come to be handed down.
Yes.
So I think we are not going to decide one way or the other today whether to admit or exclude the evidence, but we will consider it.
Yes, it wasn't clear to us from the order of Lady Justice Whipple whether he would be willing to consider it today. I know if it's helpful to say the other side had said in the correspondence at that stage that they would wish it wasn't appropriate for you to decide it today because they would wish to inspect the underlying documents, they would wish to cross-examine on it, potentially file evidence and response. But that suggestion has not been followed up in the correspondence. We've invited them to inspect the documents or to identify what in the evidence they object to in the hope of progressing matters, and they haven't. So as we see it, the arguments about the evidence are just legal arguments, not questions about the evidence. So in that sense, we don't that would not be a reason for a further hearing. But of course, I recognise. I think what the court is saying is it doesn't wish
Mr.
to.
Pearce-Smith's accepted that if, for whatever reason, we were to send this back to the High Court, then your evidence, the additional evidence, would be admissible.
Yes, I think it's his position that the evidence is not admissible to you in deciding whether or not to set aside the judge's order, and we disagree with that. We say it is admissible, and moreover, it ought to persuade you not to set aside that order, even if you think the judge back in 2024 made a mistake.
Yes.
I think, can I just confer with my leader? I've just been asked to clarify, and apologies if I've misunderstood, but whether you do wish to hear submissions from me on the consequences, should you take that evidence into...
If you wish to, by all means.
Yes.
You do address this in your skeleton argument.
Yes, exactly, and I was proposing to elaborate on those. I apologise if I had misunderstood the court before. I had thought you were suggesting you didn't wish to hear from us further on that point and would consider it in your judgment. But yes, so our position, as I said, is that having regard to what has happened in the 16 months since the judgment was formally handed down, that being the evidence which is set out in Matthew's Respondent's 8th witness statement, it would not now be right for the Court of Appeal to set aside the judge's order or to order a sale, even if this court believes the judge's decision was vitiated by error. The relevant facts are set out in the 8th witness statement of the respondent, which is at page 265. As he explains in his statement, he and his wife, if I may call them Matthew and Hayley, are now carrying on a business together in partnership. Pursuant to the judgment, the then assets of the partnership were acquired from Daniel by means of a loan from HSBC in the joint names of Matthew and Hayley, and in respect of which they're both personally liable. That loan is secured over the land, which is held in Matthew's name, and the other assets of the business, which are owned jointly by Matthew and Hayley. There is an agricultural charge over those. Daniel was paid the sum of roughly £2.8 million as determined by the court below, and the accounts and inquiries have since been fully concluded, resulting, I believe, in a small balancing payment from Daniel to Matthew. The 8th witness statement also explains that a number of other decisions have been taken in the running of the business. To summarise those briefly, at paragraph 17 and following, it's explained there's been a very significant investment in machinery since the judgment was handed down, due to the to the underinvestment, as it were, in the period during which there was a dispute and matters were being litigated. Hayley and Matthew have also entered into contractual arrangements with third parties. At paragraph 27A, that gives details, for example, of the arrangements they've brought to forward buy various crops and stocks, so that those commitments take them into the future in terms of being committed to buying those products at prices fixed now. There has also been a commitment by them to grow and to buy, for example, certain amounts of maize, that's at 26A. They've also entered into a sustainable farming initiative. They've taken on new employees, and Hayley has left her previous employment and now works full-time at the farm. Now, those are not matters that can be unwound by this court. So Matthew and Hayley and those relevant third parties will have to live with the consequences of those decisions, whatever this court now decides to do. But the net result is that things have changed as a result of the judgment, and Matthew and Daniel cannot just be put back into the position that they were in as at the date of the judge's order. This case is a world away from the case of Bahia, where there were a number of investment properties, residential and retail properties, which the court, in fact, it didn't even need to unwind the sale of those properties. It could simply order that they be transferred by the person who was then handing them. But in this case, the assets of the partnership have changed since the judgment was handed down. Further details of that are given at paragraph 34 of Matthew's 8th witness statement at page 273. As he explains, stocks have been used up. The raw materials that he got from he purchased from Daniel pursuant to the judgment are no longer in existence. I mean, other stocks may have been purchased, but not necessarily the same ones or in the same amounts. Animals have
Or indeed in the same partnership.
Or indeed, yes, of course, or indeed in the same partnership. Animals have been bought and died, been brought in and out of the herd, and as explained, machinery has also been scrapped. In other cases, new things have been bought. So the former assets aren't just all sitting there waiting to be made subject of the court's order. The ownership of the assets has also changed. In particular, and as explained, Hayley is now the joint owner of the stock and the machinery. And I don't think that there is any suggestion from the appellant that this court would have any power to compel her to transfer those assets. She's not even a party to these proceedings. I mean, the bank are also another relevant third party. They now have a new charge, as my learned leader explained, which is secured over the now assets. Just focusing on the case of the land, which remains in the ownership of Matthew, if this court were now to order a sale of the land, that will, we submit, cause prejudice to Matthew and to Hayley. Leave aside for a moment the position of the bank, but as explained, Matthew and Hayley have invested very significant sums of money in acquiring a business that makes no sense without the land, and they will lose the benefit of that investment without the land. As Matthew explains in his 8th witness statement, the other assets, the stock and the machinery, would have to be sold by them at a likely loss. So that would encompass the machinery, the stock, the livestock, in relation to which there's also a TB issue. So there is potential for very serious losses. In that sense, they would also be liable to contractual penalties under the various agreements that they have entered into to forward purchase, and ensuing likely reputational harm in the event that they cannot comply with their contractual obligations. And there would also be a tax bill payable on, in the case of the land, were the court to order it, a tax bill payable on the sale of the land at a rate of capital gains tax that is higher than the rate that applied when the land was acquired by Matthew. And in the case of the assets, if they were to be sold by Matthew and Hayley, then they would also be liable to income tax. Now, I accept that those losses would not, as it were, come to pass if Matthew and Hayley turned out to be the highest bidders for the land in a sale ordered by the court. But that just shows, I mean, the risk to them in that scenario is the risk that they would be overbidders. I mean, they are now truly in the position of being special purchasers with respect to that land. They own all of these assets, which are simply no good to them without the land, and they stand to suffer significant losses if they have to get rid of those assets. So I think that Daniel's sort of submission is that, as it were, the open market sale would be a way of eliciting what the land is really worth to Matthew, and that is why it would be fair. But it plainly wouldn't. A sale now of the land would not be a way of eliciting. Well, it would elicit what the land is worth to him now, but the land is worth to him now something because of various things that have been done in pursuance of the judgment. Yeah. It is not worth what it was worth to him in 2024 when the judge made his order, and when he was not, I mean, when the assumption was everything was being sold, and so he wasn't holding some of the assets and having to be faced with the decision whether to purchase the others. Secondly, that assumption also, I think, wrongly assumes that Hayley and Matthew could, in effect, hold on to the assets pending an open market sale of the land by this court. As Mr. Jordan explained, the evidence at trial was that typically that might take 6 to 9 months from the date on which this court were to make such an order. And Matthew's evidence at trial, which I think that the judge accepted, was that a sale would be a disaster. There would be real problems with staff retention. Staff would leave. Without staff, there would be
Those are all matters which the judge considered.
Yes, but if you're being called upon to exercise your discretion now to order an open market sale, they would
be as relevant now as they were then, but you don't need the extra evidence, do you?
No, save that not to put the other side's case, but the position's slightly different in the sense that on this assumption, you're now the heir of the land. But yes, so the evidence was that yes, staff retention would be a problem. Without people to look after the cows, they have to be sold. Without cows to milk, you cannot pay, you cannot service the loan to HSBC. If the loan's not serviced to HSBC, they're likely to get nervous and appoint receivers. And Matthew and Hayley would be liable personally, as well as under the charges, for the costs of that. Again, they're not factors that. So they are all risks to Matthew and Hayley, sources of prejudice in the event an open market sale were now to be ordered. One final point on that is it also assumes that Matthew would now be able to borrow from the bank the money that he would now need in order to purchase the land. He has had to take additional borrowing in order to purchase Daniel's share and in order to finance the additional investments that have been made in the business since then. So there's no, there's no evidence, as it were, that the bank would necessarily be willing to lend him the money. I mean, what the bank would be willing to lend him now is not necessarily indicative of what the bank would have been able to lend him in 2024. So again, it's just another respect in which the court, in ordering a sale now, is really not mimicking
I don't
what
think
on
that
this hypothesis.
This isn't covered in the new evidence. This is just a submission.
On the bank borrowing.
Yeah, we have no idea what.
He says he's concerned that they wouldn't be able to finance the debt. He said if the court orders a sale, paragraph 36. Oh, that's the tax position.
Yes, that's tax. But he doesn't say that the bank won't lend the money, does he?
No, he certainly doesn't. He doesn't say the bank won't lend him the money. No, that is right. But if the thought is that you're mimicking, you're getting Daniel now to pay what the price he truly puts on the land now, that will be affected by his ability to borrow money now, which is not the same as his ability to have borrowed money in 2024, when on this hypothesis it's thought.
I'm not sure that's a submission that's grounded in any evidence.
Okay, I will leave that. Now, the appellant's response to that argument, in effect, is to say, well, so what? Matthew and Hayley knew what they were getting into. And I think the implication is that there's nothing unfair in the consequences that flow from those decisions. But that ignores two important points. The first is that in the absence of a stay, which the appellant chose not to apply for in this case, Matthew and Hayley were entitled to act on the basis of the judge's order. We refer in our skeleton argument, I imagine your lordships are very familiar with it, but the decision of Sir Nicholas Brown Wilkinson,
Yes.
Vice Chancellor in Hillgate House, where he makes the point that,
Yeah.
yes, I won't. But so even if the order is now set aside, if it were to be set aside by the court, that would not show that they were not entitled to act on the order while it was in force.
But the flip side of that is that you knew the order was being appealed, so you were running the risk knowingly of the order being set aside.
Well, I think the other side's, I mean, perhaps this is a way of making the same point. The other side's response is to say, they weren't obliged to apply for a stay, and we're sort of wrongly trying to suggest that they were, and that there's some procedural rule to that effect. I mean, that's absolutely not the case. We're not saying they were obliged to apply for a stay, but the point is, if they don't apply for a stay, then they can't be surprised about the fact that people act on the basis of it. That is what you are entitled to do. Now, the second, I think, more important point, and Matthew makes this point in his witness statement at paragraphs 23, 24, 25 and 41, but they couldn't just sit still and do nothing. This is a working farm with 2,500 animals on it. They have to be fed and watered and looked after.
But
I mean,
surely, I mean, if that had happened, if there had been some sort of mistake, the court would have appointed perhaps Matthew, perhaps somebody else, as the receiver of the business to run the dissolved partnership until such time as this court had decided what to do on appeal. So, I mean, the fact that this is a working farm, in that sense, has got nothing to do with it, because there are mechanisms which the court can employ in order to ensure that working businesses don't just crumble while the court's deciding what to do. And the appointment of a receiver to run the partnership, to manage the partnership, would be the obvious course.
Yes, but that would have been at cost to the parties.
No doubt, but I mean, the way that you're putting it is to suggest that, well, they had to do this, otherwise the whole thing would have gone fut. But that's not necessarily the case.
Well, no, but if they didn't have to do it, somebody had to run the business. I mean, we don't know what would have happened. I mean, they didn't apply for a stay. We don't know what would have happened. I mean, maybe as in Bahia, there would have been a request for expedition. I mean, in that case, you had, again, some straightforward residential or retail properties, which, I don't know if they're sitting empty or they're being let or managed by a receiver, but there's not the constant stream of decisions that have to be made, as with a dairy farm of this magnitude and scale, about, how much, to feed the animals, how much, maize to grow. It's not a sort of straightforward case in which, I mean, even if the receiver was the person making these decisions would still have been made. And there is no suggestion, and nor could there be, that these decisions were somehow taken with a view to stymieing the appeal or making Matthew and Haley immune from the court's jurisdiction. I mean,
it is though an unattractive feature of this that you are in effect saying that, supposing that the judge's order was flawed and should otherwise go, it has become inviolable because of things you have done since, knowing that there was an appeal pending.
Well, I don't think we're saying it's inviolable, but I think what the fundamental point is that if this court decides that the judge got it wrong, both parties will have been a victim of that error. It's not the case that, it's only Daniel who has been wronged by the fact that, let's assume, the judge got it wrong. My clients have also acted on the basis of what the court said that they were entitled to do, and so it's wrong, I think, for the appellant to suggest that somehow this court, in deciding what to do now, can or should just ignore the harm that will be caused by undoing the consequences of the judge's order below. The truth is, if this court finds the decision was wrong, then both sides will have been victims of that error. And the question then is, well, what should this court do?
Well, that's what Lady Justice Whipple
Yes,
says.
but we say, in approaching that question, the court has to weigh up the injustice. Yes, I think in answer to Mrs. Newey's question, we accept that there is an injustice to Matthew if this court concludes that the judge got it wrong, but this court nonetheless thinks, for the reasons that we have given, his order ought not to be set aside, or that
would be an injustice to Daniel.
We accept that, but there is an element of injustice that is inherent in that. But the injustice that is inherent in that, in allowing, in effect, that order to stand, is that it means that Daniel, has to be, the situation is left where Daniel is bought out at a figure which the independent expert evidence suggested was what his assets what his interests were worth on the open market. That evidence was thoroughly investigated at trial. So again, quite unlike the case of Bahia, and in circumstances where he himself has made no better offer to purchase the land, either before, or the assets, either before or after the judgment. I mean, even once the judge had said, this, Matthew, is how much you will be paying in order to acquire Matthew's interest, he hasn't offered a pound more, which is what my Lord Justice Newey suggested is all he would have to pay in an open market sale. He hasn't offered anything more. So the idea, as it were, that there's some sort of terrible misjustice to him in not being able to make a bid for the land. Well, he could have made a bid for the land. He hasn't done so. And in any event, he has been paid what the expert evidence suggests his interest was worth. And the court routinely, there's nothing particularly unusual about that, about people's interest being brought out. I mean, there's nothing objectionable per se about buying someone out at a price based on a process of
Yeah, I think this is
valuation.
going rather beyond your application to admit the evidence, but there we are.
I'm very sorry. I've come really to the end of my submissions on that. So I say once you balance what the risks are and the potential injustice to either side, given that the court has no perfect solution, that this court ought not to set aside the judge's order or now to order the sale. I'm grateful.
Thank you. Yes, Mr. Pearce-Smith, you want to reply on the appeal and oppose the application?
Yes, I'm going to do it in the other way around.
Yes, please.
Just dealing with the application first of all. As a general point, it's very difficult for my clients to respond to an application of this nature when it's supported by a lengthy witness statement, which contains a great deal of assertion, some of which isn't explained. A lot of reliance is placed upon the fact that Hayley is now a partner of Matthew, but there's no explanation for that. It's not something that we're able to test or to understand. And if it's said that the fact that she is a partner in some way prevents this court from setting aside the judge's order, well, you shouldn't do that simply on the basis of a witness statement of that nature, when there is nothing that we can do to go behind it. It's simply an assertion. To the extent that there are financial matters, if, and I underline the word if it's the case that as a result of the original order and then the subsequent setting aside of that order, that the same thing now, that Matthew makes a loss, or even Matthew and Hayley makes a loss on an item of equipment or a crop or whatever it be, then that is something which can be dealt with or at least addressed in the accounts process, which will inevitably follow if the matter is remitted to the High Court. So in the end, there may be a sum of money which can resolve that unfairness. We don't know what that sum of money is, because all we have are assertions by Matthew. We have assertions about what he's purchased, and I'm sure that he'll prove that he purchased what he's purchased. But in terms of the losses, if there are any which flow from those sorts of matters, it's impossible for us to deal with that in this court in this way, which is why it's difficult to deal with. And I think my Lord Justice Newey has my point about the effect of the stay. Essentially, the gist of the claimant's, the respondent's application is that if you don't apply for a stay, then you can't then challenge what happens. And of course, then that means that the success of this appeal depends upon the court's discretionary decision about what to do in the event of such an application, which, and it's another matter of speculation, would no doubt have been opposed by the respondent. And that would be an unsatisfactory state of affairs. So my primary submission is you shouldn't admit this evidence on the question of whether or not you should set aside the judge's order and substitute the order that we've submitted that you should make. If it is to be admitted at all, it should be at the stage of considering effectively the accounts process following that.
So Ms. Fairley said she was relying on it for two purposes. One, to persuade us not to set aside the judge's order if it was otherwise wrong.
Yes.
Secondly, if we were to exercise our own discretion, take that evidence into account. And your response, as I understand it, is we should not admit the evidence at all for the first purpose.
Yes.
And if we were to come to the decision that the judge's order should be set aside, it shouldn't be we who exercise the discretion, we should remit it back to the High Court. Is that right? Or do you accept that we should exercise our discretion? And if so, should we take into account this new evidence in doing so?
I accept, or I submit, that you should exercise your discretion, and you shouldn't base that discretion on this evidence, because this is evidence which it can't be tested or challenged in any way by the appellant, and therefore it shouldn't be allowed in for that purpose.
So that goes to the quality of the evidence, not the principle.
Well, if evidence is such that there is no way for a party to be able to respond to it, then that goes to the principle as well as the quality, I would submit.
If, on the other hand, we were to set it aside and send it back to the High Court, you would have the opportunity to challenge it.
Well, that is correct, but there may be parts of it. This is the problem about the evidence. It's sweeping evidence. It covers all sorts of points. It puts forward all sorts of different disastrous scenarios, which of course the respondent is bound to put forward. Some of those go to the question of whether or not this court should exercise that discretion, and some really go to financial matters, and they're not. Well, one can probably form a view about which goes to which, but you're being asked to admit the whole thing, not just to admit parts of it. And in my submission, that would be unsatisfactory, and the court shouldn't do it.
Yes.
I'm going to then respond to my learned friend's submissions on the appeal itself. I really just want to stress the point that the judgment is based upon the 2005-2006 conversation. The way that the case is pleaded uses that as the basal point, as it might be described, and the judge doesn't address that critical building block in his judgment. He simply passes by, and this is not a reasoned appeal, as my Lord Justice Nugee has pointed out, but it is an appeal based upon the judge failing to take into account matters which he ought to have taken into account. And it's essential in my submission, on any case of proprietary estoppel or an equivalent, that the judge sets out the key elements, the key points which in this case I raised in my oral submissions at the end of trial, which are in the bundle that I haven't taken you to, but there are page references. And it's important partly so that the parties know what is the basis of his decision, but it's also so that an appeal court can see whether or not he approached the matters correctly and took all of the appropriate things into account, and he singularly failed to do so. It's a very long judgment, and yet it skates over the key factual points. I say skates over, it doesn't even deal with. My Lord Justice Newey asked the question about whether or not the judgment deals with the conversation about the children's inheritance. My learned friend responded that Matthew accepted that in evidence. He did accept that in evidence. He accepted that in cross-examination, and he dated it 2015. It's not mentioned in the judgment, though, so we don't know what the judge made of that. I raised the point in my closing submissions. I expressed it to be an important point as well.
How do we know this isn't a reasons challenge? I mean, we've discussed a lot paragraphs 392, 394. 394, the judge says Matthew has established such an equity, presumably an equity along the lines of 392.
Yes.
Now you say, well, it isn't apparent from that he's taken into account this, that, or the other. But how do we know he didn't take those things into account and just didn't spell them out in his judgment? How do we know it isn't just that he hasn't set down his reasons as fully as you would say he should have done?
Well, the short answer is we don't know that from the judgment. But in my submission, it's incumbent on the judge to take an appropriate course which goes carefully through the necessary components for the equity which is being relied upon, which is, as we know, the proprietary estoppelish equity in this case, and it explains his reasoning. And
That is a reasons challenge.
The challenge is that he failed to take into account matters which he should have taken into account.
So the challenge is he failed to say he had taken into account matters which he should have done.
Yes, maybe I viewed that as being something that he'd failed to take into account, because if he doesn't say that he's taken something into account which has been raised in submission, then
you
my
infer
submission,
he hasn't.
one can infer that he hasn't indeed.
I mean, potentially, though, that could be most unfair. I mean, the judge has all these things in his mind, we suppose for a moment, and he's expressed himself economically through paragraphs 392, 394. Suppose he did have all these things in his mind. Would it be the right answer to say, no, you win? There's no question of a proprietary estoppel-ish answer to this case, because the judge didn't explain that he'd had all these things in his mind.
Sorry, I was going to answer a question with a question, which I probably shouldn't do. Unfair to whom? Perhaps I should take you to my closing submissions then, and
It's in the supplementary bundle, is it?
It is in the supplementary bundle, yes. And closing the submissions, the relevant pages start, I think it's page 208.
Yeah.
And having referred to the decision, the first instance, and for Justice Zaccarelli and Winter, which is at the bottom of
Yes.
page 646, and the next page, 647, I start my submissions in relation to proprietary estoppel. And I say at the bottom of that page, one of my points will be that the alleged conversation in 2005-2006 is simply not sufficient to be an assurance to base everything on which the claimant runs its case.
Yes.
Then if you turn on to the next page, 209, transcript page 653, at the top, first few lines coming back to the
Yes.
conversation. Again, the whole case is based on one conversation. You have to be satisfied that it was a conversation of the type which is sufficient to give an assurance,
Yeah.
etc. At the bottom of that page, I refer to the evidence that Daniel was upset, and on the next page, so transcript page 654, I deal with the point about him being upset. If
Yeah.
he was upset and so on, it can then have been because he had a conversation with Georgina. I point out that if you're upset, it's not a rational conversation which you have with somebody who is upset. Somebody's saying Georgina's going to leave me, I'm going to have to go. It's not a solid basis, so that goes to the quality of the assurance. At the bottom of the page, I raised the issue, this is line 18, I think there's a misprint here, but indeed, first of all, is it a statement of intention as opposed to an assurance, excuse me, and I refer back to Winter for that. Is it something which should be understood as on which the party should act? I point out it's a one-off conversation. Then on page 655 of the transcript, line 9, context is everything. I refer to the fact it's a proprietary estoppel case. And I submit that the context feeds into unconscionability as well, because in my submission it was important not just how Matthew understood it, but what Daniel could reasonably have been understood to be saying, and so on. I then at top of page 656, I say the context is absolutely crucial. It's all about Georgina and it's all about Taunton. Line 10, context is very important. Daniel hasn't moved to Taunton. He hasn't wanted to leave the partnership. There's been a partnership breakdown, but there's no suggestion that this conversation touched on partnership breakdown or any of the possibilities. In the next paragraph, 18, I refer to the pleading, and I point out the importance of precision in the pleading, context and so on, relating to Daniel leaving Georgina to move to Taunton, and refer again to the crisis. And I point, and at the bottom of that page, the importance of this is once that moment has passed, once this crisis, if this is what is said to have happened between Daniel and Georgina had passed, then it cannot have been reasonable for Matthew to understand that that continued to be the situation. And that was the point. And I asked, I mentioned it in my skeleton, but I asked both of them about that, and they were both evasive in my respectful submission. And I asked the question why Daniel should have realised that Matthew was continuing to labour under that misapprehension. I pointed out the evasiveness on that page 657. I give the judge the references in the transcript, which have been produced on a daily basis during the trial, at page at line 14. I then put a date on when I submitted that they must have become it must have become apparent that the crisis was over. That's at lines 14 and so on. On the next page, page 658, at line 6, I said what it means from that point, 2008, it was unreasonable from that point onwards for Matthew to treat that as an assurance on which he could rely in the way it was said in this case. And perhaps I was getting repetitive, but I made the point again at page 659, at line 10. At line 12, I say you should find there must have come a point. It must obviously be about 2008, and so on.
Point,
You've got that point. So, I'm sorry, my lord. I'll move on. But there are other points as well.
Bear in mind the time.
Yes, I'm sorry. Just to move on then. So the next page 2112, bottom of 664. I point out again, Matthew has to establish the necessary elements of the proprietary estoppel, detrimental reliance, and so on. It goes to unconscionability, and it's why should Daniel appreciate that what Matthew was doing at this stage in 2011 to 2013 was being done on the basis that he had a right to the empire at some stage in the future, and I refer back, and so on and so forth. So perhaps I was going on too much about it. But what I was doing is I was emphasising these points again and again, and I also emphasised the points in relation to the 2015 conversation, and I addressed the nature of the conversations, the rows which happened after 2013, and I pointed out their lack of causative potency, bearing in mind the date of the reliance, and so on and so on. So these were points which I made and stressed the importance of. And in my submission, in such a long judgment, for the judge not to have dealt with these fundamental points, any of them, frankly, is wrong. It was wrong of him in this approach, and that is why, perhaps that is the main point, why the judgment was wrong and why we say it should be set aside.
Right.
Is there anything else I can assist your lordships with?
No, thank you very much. Well, it's clearly a complex case, so we will reserve our judgment. You will get draft judgments in the usual way. They come subject to a fierce embargo, which means what it says, so it can be distributed only to those on the list which has been submitted to the court. The receipt of the draft judgment is your opportunity to correct our English, but not our reasoning, or to introduce new arguments. We would hope that in the light of the drafts you will be able to agree an order disposing of the appeal. If you can't agree the formal order, please make short written submissions and we will make the order that we consider to be appropriate. Hand down when it comes will be electronically by email to the parties and released to the National Archives, so there will be no need for any further attendance. Thank you all very much.
Rise.